Good morning, good afternoon, or good evening, depending on your time zone. My name is Maeve McDermott, and I'm serving as the Zoom host for this session. It's my distinct pleasure to welcome you to this session on accelerating climate action through pro bono. With that, and this session is being hosted by the Advocates for International Development. And with that, I will turn over to Advocate Yasmin Batliwala, who is the Chief Executive of A4ID. So, Yasmin, the floor is yours.
Thank you very much. And greetings, everyone. And on behalf of Advocates for International Development, I wish you a very warm welcome. Thank you for joining us at this session on accelerating climate action through pro bono. This session is part of the Climate Law and Governance Day initiative, and we're very grateful for the team for including us in this important event. Indeed, we're truly delighted to have the opportunity to participate in this way, as the goals of A4ID and the initiative are so very closely aligned. As you all know, the devastating impacts of climate change are being felt across the globe, from extreme weather events to rising sea levels, from food insecurity to displacement of entire communities. The urgency is undeniable, and the need for collective action is clear. As the world therefore looks toward COP29 with renewed urgency to strengthen global communities and address the climate crisis, it is really vital that legal professionals consider the critical role that they can play in this agenda. The window for meaningful action is narrowing, but the potential for transformative change is very well within our grasp. Legal professionals occupy a unique position in society, while many may associate the legal profession with the preservation of justice. What is less obvious is the potential for the law to be a powerful tool in the fight against climate change. Indeed, legal frameworks can either impede or accelerate the actions needed to tackle climate change, and that's where each of us can make a difference. Pro bono work has always been about access to justice and advocating for those who may not otherwise have a voice. Today, in the face of climate change, this mission is more critical than ever. Pro bono legal efforts can help drive environmental justice, protect vulnerable communities, and support the development of, and enforcement of regulations and that safeguard our planet. At Advocates for International Development, we are committed to harnessing the power of the law to support sustainable development, including the urgent need for climate action. However, accelerating climate action through pro bono legal work is not simply a question of dedicating time and resources to the cause. It's about leveraging our expertise to navigate complex regulatory environments, advising businesses on sustainable practices, holding governments accountable to their commitments under the international agreements like the Paris Accord, and helping communities defend their environmental rights. In short, it's about catalyzing systemic change. COP29, as with previous conferences of the parties, brings together governments, corporations, civil society, as well as other stakeholders to accelerate global climate ambitions. At COP29, discussions will once again and have once again turned to how countries can strengthen their nationally determined contribution to meet the Paris Agreement. But if we are to achieve the ambitious goals outlined in the Paris Agreement and go beyond, the law must serve as both a foundation and a tool for progress. And this is where pro bono legal work becomes indispensable. Many of you here today have already perhaps contributed significantly to these efforts, whether through advising environmental policies, representing those most affected by climate disasters, or even providing legal expertise to climate-focused NGOs. Well, I'd like to acknowledge all of those efforts. But as we know, the scale of change means that much more needs to be done. We need a legal framework for climate action that is ambitious, adaptable, and comprehensive. as the solutions themselves. We are at a pivotal moment where the intersection of law and climate action is rapidly evolving. The legal community must be at the forefront of this transformation, ensuring that climate action is grounded in robust legal foundations that guarantee fairness, equity, and effectiveness. So today's session is about exploring how legal professionals can maximize their impact, how we can collectively amplify pro bono contributions to accelerate climate action. You will hear from experts who have groundbreaking initiatives in the space, and we'll also explore strategies for how pro bono legal work can support everything from climate litigation and corporate accountability to the protection of Indigenous rights and advancement of sustainable development goals. So today's session is an opportunity to reflect on the crucial role that pro bono legal work can play in accelerating climate action, particularly to support the ambitious agenda which has been set out in COP29. We'll hear from leaders who have been driving climate initiatives on the ground and explore how, as a community of legal professionals, we can scale up our efforts to support the COP agenda. So I encourage each of you to think creatively about how to use your legal skills to contribute to the global response to climate change. A4ID's work shows us that pro bono legal assistance can make a profound difference, from shaping international agreements to supporting local communities. So as we embark on these discussions, let's be reminded that the law is not just a reactive tool, it can be a proactive force for good. Through collaboration, innovation, and a shared commitment to justice, I believe we can make meaningful strides in the global effort to combat climate change. So thank you very much, all of you, for being part of this critical conversation, and I look forward to the insights and ideas that will emerge today. Our moderator for this session is Elizabeth Wu, who will skillfully navigate us through our discussions. So Elizabeth is a legal consultant for ClientEarth Asia in the energy systems team. She has vast experience in the legal sector, having practiced international arbitration and litigation, and has also worked as a state counsel within the Attorney General's Chambers of Singapore. So let's begin. Over to you, Elizabeth.
Thanks so much, Yasmin. And thank you everyone for joining us for this session. We're very delighted to have you with us. I'd like to introduce the excellent panelists who are going to be engaging in the discussion. Let me start with Mr. Roger Leese. He is the Chair of Advocates for International Development. He is also a partner with Clifford Chance and co-heads the firm's global business and human rights practice, and has a wide range of expertise in various forms of commercial, banking, and financial services disputes. Next, we have Mr. Jake White. Jake is the head of legal at the World Wildlife Fund, United Kingdom, and he has rounded experience working with the government, NGOs, and with law firms over the last 20-odd years since qualifying. He has deep experience in environmental advocacy as well as human rights-related issues. Next, I'd like to introduce Mr. Matthew Gingell. He is the General Counsel of Oxygen House Group and the founder of the Chancery Lane project. He is widely recognized as an innovator who is helping shape the legal profession as a force for good. Moving on then to Ms. Pricila Cardoso de Aquino. She is a Brazilian lawyer with a master's in social environmental law. She leads climate change and Brazil-related cases at the Environmental Defender Law Center and heads the Environment and Climate Law Pro Bono team at Natividade Advogados. And she has been working on the risks associated with climate change in the Amazon region. Finally, we have Mr. William Hooker, who is a partner at Alston and Bird's London office, where he practices in international arbitration and commercial dispute resolution. He has acted in a large number of climate-related mandates on a pro bono basis, including providing advice to states participating in COP negotiations and supporting NGOs in litigation. So without further ado, maybe I'll just ask Roger to kick us off in this conversation. And it would be great to get your reflections, Roger, on the ecosystem of pro bono legal work and the various areas and actors involved. So for instance, pro bono work relating to working with regulators, advising on climate finance, or supporting active litigation.
Thanks very much, Elizabeth, and welcome to everybody to this event. So I think the main point I would start by making is that lawyers can give their time for free, in other words, pro bono, across so many different sort of relevant pieces of this enormous jigsaw, which is trying to deal with the climate crisis. And actually, Yasmin, in her introduction there, gave something of a flavour of that. But if I could build a little bit on what Yasmin was saying, and the way maybe I would break it down is that lawyers and law firms can and are involved, both if you like, in direct advice and assistance to those on the front line, whether they be states or they be NGOs or they be communities. And then I think lawyers can play and do play a significant role in terms of, if you like, the knowledge required to deal with climate change. So actually, if you like, what we might call thought leadership and development. And that can be lawyers working with other lawyers and with other law firms in a collaborative way, which obviously in most other areas we don't do. Or it can be working, as you just mentioned, Elizabeth, in assisting regulators or governments, thinking through how they might design legislation or regulation around this area. And then, of course, there is a piece here that can be around challenging states or businesses or other players in relation to their commitments through quite a wide range of methodologies, whether it's shareholder activism or it's complaints, or whether it's advertising standards, etc., etc. It's a whole range, as you very well know, Elizabeth. So just to touch on a few of those and give a couple of examples. So I think one important thing that's been going on for years has been pro bono assistance, in particular to states looking to participate within COP negotiations, who don't otherwise have that support. And for many years, there's been something which quite a lot of lawyers and a lot of firms in London have been involved in, called the Legal Response Initiative. And actually, I see there's also now a Legal Response International, sort of as part of that as well, which is really, if you like, galvanizing and bringing together lawyers from across different firms to provide that assistance to, in particular, to developing nations who are looking to participate in COP. Because as we all know, at COP, some developed nations turn up with small armies of advisors and negotiators, etc. And there are quite a lot of countries who basically have very little resource to be able to bring to bear to argue their point of view in these critical negotiations. And obviously that relationship between developed and less developed countries is a key cornerstone of negotiations at COP. Then we get, of course, the support for a whole range of NGOs that are active in climate change. And I suppose I mentioned the obvious one today, which is Advocates for International Development. And the many law firms around the world are a part of Advocates for International Development. And Advocates for International Development, one of its core roles is to work with NGOs to develop their thinking on what help lawyers can give over the whole range of SDGs, but obviously 13 is very much there, and then being able to go out to a vast number of lawyers to see who's best placed to help. And then I think I probably would want to talk a little bit about that third element, which is, if you like, lawyers looking to work within the legal community to develop thinking and so on and so forth. And I know Matt can talk a lot about this from the Chancery Lane project. So I won't talk, Matt, about, I'll leave you with that one. But another organisation I mentioned that I've been working with has been the Net Zero Lawyers Alliance, which is actually part of the UN's Race to Zero. To be part of that alliance, you have to make a commitment in terms of your own firm's actions in relation to climate change. But then that's the beginning of it. Actually, and the NZLA expects a commitment of member firms to doing pro bono in relation to climate change and the climate crisis. So that's a key. But then also within the NZLA, we've got a number of what we call accelerator groups, actually looking to research and bring to bear legal thinking on some sort of key issues around climate change. So at the moment, we've got 5. We've got one on antitrust. Many people may know this is always an issue. How far can businesses collaborate without falling foul of antitrust laws? And actually, having the sort of brains there to sort of develop the guide rails to allow businesses to feel comfortable working together and collaborating on climate change is really important. We have another one on project finance. How can you make sure the climate crisis and climate change is really taken account of when businesses and actually international development banks and so on and so forth are engaged in project finance? Fiduciary duty is always a big thing. To what extent can an investment manager take into account climate change in making investment decisions? As we all know, a big battleground and absolutely crucial. International trade law speaks for itself. And then one which we've just set up and that I'm helping to develop is actually around the just transition, which, as we all know, is crucial. So, there's a real need there for lawyers to be, as you said, bringing those brains and experience to bear to try and develop thinking which is pro climate action in all of those crucial areas. And then, as I said, there's a number of other bodies, that are working to bring lawyers together to collaborate, to as I said, to either assist NGOs, assist states, or work with regulators to develop climate-friendly regulation, if you want to put it that way. So the whole range of that, there you can see a whole range within this ecosystem, Elizabeth. So I'll stop there. There's a lot more I could say, but I will stop there.
Yeah, sure. No, thanks so very much for that. And actually, since you mentioned Chancery Lane project, it will be great to pass to Matthew on this. But just right before I pass to Matthew, I just want to say to everyone participating also, there'll be a chance to have a question and answer session at the end. So if in the course of any presentations you have any questions, just feel free to pop them into the chat. We'll collate them and then we'll address them later on. But anyway, let me move to Matthew then. And I think it'll be great to hear from you on how the Chancery Lane projects work on various issues, including climate aligned clauses, fits within the ecosystem of accelerating climate action, following on from Roger's comments.
Yeah, thank you. And good morning, good evening, good afternoon, wherever you are in the world. The way just to build on what Roger was saying, the way I see it in very simple terms is there's 4 legal levers that we can pull as lawyers. We can pull those with pro bono, of course. These are climate litigation, which we'll talk a bit more about. There's climate policies and laws. There's climate legal governance, and then there's climate contracts. And those are the 4 levers we can pull. And when thinking about those, you also have to think about the business of law and the clients of law. And what we do at the Chancery Lane project is we use contracts to turn climate action into reality and to deliver transition plans for businesses. And so the way that it works is that because contracts are a normal part of economic activity, you have the alignment with the business of law and you have the alignment with the clients of law. And the other advantage that contracts have in climate action is they can be immediate and lasting. They can also be local and global. Laws are constrained by time, and sometimes getting a climate law or policy change takes more time than a sloth doing a marathon through a desert, is the way I describe it. And so you've got this instant and lasting effect of laws which are local and global, as I said. But without pro bono, the Chancery Lane project as a charity, as an international NGO that it is today, does not exist, and the doctrine of using contracts for climate action does not exist either. And pro bono was this magical convening power that brought the best and brightest minds together from across the legal profession to co-create know-how and thought leadership in the form of drafting contracts. And that co-creation, that democratization of the solution is incredibly powerful because it means we're all invested. And once we're all invested, we all want to use it. And that is why it's been so successful. So pro bono has this really magical place for lawyers. And I think we've got to rethink what we mean by pro bono, because I think, if you look at how it's defined by bars and law societies, it's very narrow. And I think you have to expand it to climate in the way that we have at the Chancery Lane project. So perhaps pro bono et terrae, or something to do with planet, needs to be in the definition. And then you can think about how you deploy pro bono to use contracts, and that may be with helping some clients pro bono to understand how this might happen, and that probably leads to extra work for the firm. So there's good that comes out of it. But how can you go and teach at law schools about how you use it in practice? How do you teach others within your firm? How do you train clients and help participate in surveys and provide the data on the contracts for research? There's all these things that I think are pro bono adjacent, where we can't charge for our time, but they're really important to understanding which solutions will work and which won't. Because ultimately, if we don't all do it, then we're never going to change the world, and we're never going to get to net zero, because we have to bring everybody with us. And part of pro bono that I think is really powerful is we democratize the solutions when we collaborate.
Thanks so much for that, Matthew. Really powerful reflections. May I turn to Jake now? And it'd be really great to get your reflections on the areas of work that you think are most critical to accelerating climate action, and also what kind of work does WWF do in this area, and the role of pro bono legal work relating to that.
Thanks, Elizabeth. And just to clarify, I'm the head of legal advocacy rather than head of legal.
Yeah, I'm so sorry about that.
That's all right. It's
Yes.
a small but important distinction. Yeah, sure. So, I mean, I think the key sort of focuses or foci for the kind of UK office in the climate space at the moment, probably the top one is finance. So in other words, channeling public and indeed private finance towards the more sustainable kind of economy that we need to see. So you've got a kind of decarbonisation of the finance system, and the movement transition towards a nature positive net zero system. We've got a specific focus on deforestation. That's again a sort of organisational priority for us. And I think in this space, I mean, it's very well known, of course, the crucial role that forests play as carbon sinks. They're obviously also havens for nature. And for us, again, I think in some ways that's a kind of entry level issue to the climate nature nexus that we really want to sort of bring to the fore in this space, which takes me to my third point, which really is sort of nature and climate. That I think what we increasingly see in the legal space is an increasing awareness of, understanding of net zero and what that means for lawyers and indeed for wider business, many particularly transnational businesses. I think there is a significantly less understanding of nature and how the nature crisis, which is unfolding before our very eyes, can and must be tackled. And I think there is a role therefore for organisations like WWF to help lawyers more broadly, but obviously also ultimately their clients to better understand, to measure and to take action to mitigate in that space. In terms of sort of pro bono and how pro bono work is kind of keyed into those three areas, for us it has been very, very significant. There's no doubt about it. Despite being a relatively large NGO by NGO standards, our legal spend remains quite small. Excuse me, for all the reasons that I'm sure people on the call will recognise. I think there is always going to be a difficulty turning to supporters, and we are overwhelmingly funded by individual supporters, and explaining that what we're actually going to do is take their money and give it to law firms or give it to lawyers. That is not an easy sell, as much as on many occasions that may well actually be what's needed. In terms of the finance piece, we've had a lot of pro bono support in that area. Financial services is not an area that either myself or my colleagues specialize in, and clearly there's a great deal of expertise in city law firms in that space. So I think we've had to rely on law firms heavily to sort of help walk us through the thicket of financial services regulation. But I think there's also a thought leadership kind of role there, as I think Roger was kind of nodding towards, which is, well, in that case, what should the system look like? Or what could it look like to deliver effective transitions, the effective transition to a net zero nature positive world? And that, again, I think can be a really interesting role for pro bono lawyers to pick up. On deforestation, again, huge amount of pro bono work here. Obviously, London is a very significant, very dynamic centre for law. And we have, as the UK office, therefore, a strong pro bono network by virtue of the fact that WWF is obviously a very well recognised NGO. But as I say, also because of where in the UK we happen to be situated, i.e. because we have the sort of London legal market on our doorstep. What I think I spend therefore quite a lot of my time doing is kind of leveraging our legal network for offices across our WWF network. And what that quite often means is redistributing that wonderful pro bono support that we get to offices in the Global South. So there is a kind of sort of redistributive element. That tends to work very, very well. And again, these international firms that have offices across the world are invaluable to us in that regard, because not infrequently, the answer to the deforestation question lies in Bolivia, not in London. And that's absolutely critical. Finally, just on nature and climate, again, we've had fantastic support from law firms in particular in this space. I think it is a battle that remains to be won, highlighting both the nexus and the need for action, sort of on nature per se. But just to highlight one example, we had incredible support from an international firm based in the US on our submission to the International Court of Justice concerning their advisory opinion on climate change. I think I should probably name the firm because they just gave us such incredible support. I think they deserve it. And they're called Squire Patton Boggs, which is a US firm. They did incredible work together then with a team of 6 barristers working pro bono to us, and produced a superb piece of work, which absolutely joined up the climate and nature and brought nature to the table for the ICJ to adjudicate on.
Thanks so much for that, Jake. Really great to hear all those reflections. Maybe I should move to Will, who has himself also done a fair bit of pro bono work for ClientEarth. But in respect of a question for Will, I would like to ask how you would see the evolution of pro bono legal work in the area of climate-related litigation and legal risk, and what are some of the challenges that lawyers who want to get involved in this area can face?
Sure, I'm very happy to talk about that. I mean, clearly, Roger and Matthew have already outlined, some of the sort of discrete areas in which lawyers can lend pro bono assistance, and it's not just sort of, my end of the sort of spectrum, which is sort of aggressive litigating. It's actually setting the ecosystem, which is equally important. I'll come to a moment in sort of Matthew's work and how that potentially relates into what I do, but there clearly is also a wide spectrum of pro bono support at the litigation end. And I see really a big distinction between public law intervention, which in one sense it is somewhat easier to get involved in, I think, in pro bono, because there is a sort of more logical legal architecture for mechanisms like judicial review, and governments or government agencies, assume real sort of hard law obligations in relation to climate action. And then if they fall short on that, there is an obvious mechanism to challenge. I think where the landscape is less developed is in private law and commercial law applications. And that's obviously an area in which I've worked with ClientEarth and various initiatives. But clearly, there is a focus on the fact that a lot of climate action lies in the hands of corporates and those who put capital to work. And a lot of the work I've done is an interest in, well, in private law, by and large, legal claims and legal liabilities are to do with money. And one of the focus of the work I've done is trying to emphasize how climate action or inaction has monetary consequences, whether for shareholders or for counterparties, and trying to find ways in which liability can be explored through the sort of conventional private law mechanisms. It will be very positive if, Matthew's work and the work of others results in corporates assuming more obligations that aren't simply about money, but that are contractual commitments to do certain things or take certain actions. And certainly companies, public companies, assume some of those obligations directly or indirectly to shareholders by saying they're going to do X and then creating a framework to pursue it. So there's a lot going on, a lot more work to do, but plainly one of the challenges in the commercial legal area, to your question of what are the challenges of getting involved, is that large corporates will assemble large, sophisticated and expensive legal teams, and that is not an easy environment for charities or public sector organizations or civil society organizations to enter into that territory and take meaningful action. And pro bono support is one way of leveling that playing field.
Thanks so much, Will. I think just picking up with your point regarding, the difference in terms of firepower and some of the difficulties maybe funding litigation. So, Roger, it'll be great to get your reflections on how litigation funding fits within the ecosystem of pro bono legal work that you had mapped out. And what are some of the pros and cons that perhaps NGOs or, those in civil society should be aware of when looking at this as an alternative, if it's even a viable alternative?
Thanks, Elizabeth. I think the starting point is, and picking up on what Will said, when you look at, I think that we're really talking here about, the disputes territory, obviously. That's where litigation funding can come in. And the reason why I think certainly it's become quite an active sphere with and actually, has started to develop a place within the ecosystem is that it's really what Will said. If you've got, a major piece of litigation, it's a very big exercise to run it on either side. That is why, if there's a corporate involved, it will need, happy to say, firms like mine and others to help them. It's a very big exercise, takes a vast amount of time, and therefore is a massive cost as well, both personal and in terms of the time commitment and the monetary value of that within law firms. So actually, from my position, if you like, as the pro bono partner at Clifford Chance, committing to any sort of litigation on a pro bono, whether it be in the sort of climate field or any other field, it is actually really difficult because, when we've done it in the past, sometimes, a lawyer can end up just tied up for almost their, 100% of their time. And that's not the model for pro bono, which is something that people can do alongside their fee earning. So actually, I think for litigation, in the main, I think you need lawyers who are doing it, who are being paid to do it, whose job it is to do it, to get the best for that long-term commitment. And that, if I may say so, is actually the beauty, of course, of the ClientEarth setup. That you actually have lawyers doing this for a job. It's not pro bono. But where litigation funding can come in is it does allow some firms to do some firms. I'll name a couple that we know very well in the London market, which would be Leese, Pogs and Goodhead, who have sort of developed a model where they will take on cases where the clients would not be able to pay for the matter, but there is a monetary value to the claim, which is what Will was highlighting there, so that there is, if you like, at the end of the case, the prospect of a significant amount of money being paid over by way of damages. And because, therefore, there is a financial upside, if we can put it in those brutal terms, then you can interest investors, in other words, litigation funders, to say, if you pay for the litigation, we can basically, pay over to you a significant part of the damages, and you will therefore make a profit. And what's happened very much in the London market over the last few years is our litigation system and litigation rules has in general, there's been one recent case which has caused the litigation funding market to be thrown into a bit of disarray, but I think that's probably going to be remedied in the end. But we've developed the legal rules allow now class actions very much to be run. So it's possible for these firms to identify an issue, find perhaps even thousands of clients, and bring an action in the UK with litigation funding. And a big example of that, of that might be, actually, I don't know the details of litigation funding on this, but in terms of the class action of that type, we've got the case which is currently before the English High Court against BHP, brought on behalf of thousands of actually not only communities and people, but also local authorities, etc., in Brazil. And actually, I think maybe we'll hear more about that later. But that's, if you like, the way in which many of these actions now, have become possible to run, even though they are extremely, hard, time-consuming, costly through that way. Because as I said, actually, on a large scale anyway, it's very difficult for pro bono to be the source of support. And that's before you get into certainly issues for large firms like mine, which we have our ethical rules, of course, which actually means we can't be involved in litigation in many cases if it's going to be against businesses that we act for in various other capacities. So there's a limit to that sort of part of the picture, if you like, from a pro bono perspective, in my view.
Thanks so much for that, Roger. I think that is a great segue actually to Pricila, and I'd really like to hear from you, Pricila, on whether you can comment on challenges that plaintiffs in the Global South face in obtaining pro bono legal representation. I mean, we've heard from Roger and Will, a number of others, about difficulty in terms of funding litigation and navigating all that landscape. So how, especially with respect to plaintiffs who might be in jurisdictions which are different from the home state of the parent company, which is source of potentially the climate change issues and pollution. Practically, how do such plaintiffs navigate this, and where do you think there can be more support for such plaintiffs to access the pro bono legal help they need?
Thank you, Elizabeth, and good morning from Brazil to everyone. First of all, I want to thank H4AD for inviting me to be part of this conversation today. And about this critical but often overlooked issue, the challenges of traditional communities in the Global South face when seeking pro bono representation to assess justice, particularly in cases where litigation talks about the climate risks and environmental damages they have been facing, litigations that often take place in the home jurisdiction of multinational companies. I think we can imagine for a moment the journey of a community leader from remote Amazonian village or from a rural community in Africa or in Southeast Asia, who has come to understand that their way of life, their land, and their resources are threatened by the operations of a corporation based thousands of miles away or by the state. And they are not only facing environmental damages, but overwhelming task of navigation unfamiliar and distant legal system and to hold those responsible accountable. And they face a lot of challenges, many of which may seem unsurmountable. And first there are geographical and communication barriers. These communities are often in remote regions, far from cities where large law firms are located. This isolation complicates not only direct communication, but also the mutual understanding of the issues, the urgency, and the needs these communities express. The language at all is like here in Brazil, we have almost 300 indigenous languages, so it's not an easy work. In addition, they face, I guess, complex international jurisdiction issues. the legal system in countries where these multinational companies are headquartered are often vastly different from those in the Global South. So local communities need specialized legal representation that understand both local and international law. But this expertise is rare. And when it exists, it's frequently not available pro bono. Then we have the issue of legitimate representation. Many of these communities lack formal representation that courts would recognize, but in their traditional structures don't always align with legal expectations. So without recognized representatives, even starter cases can be a struggle. And we have the financial issue. The financial burdens are another layer of these challenges. So while pro bono service may cover legal fees, the indirect costs of such transportation, translation, evidence gathering, and expert analysis are often prohibitive. So like to arrive in the deep Amazon, we can spend like 3 or 4 days by plane, by boat. So for communities that rely on these resources being treated by these corporations, litigation may seem an impossible expense. And finally, I think perhaps the most tragically, the risk of intimidation and retaliation. These communities can face pressure from the companies involved and even from the local authorities, and this can manifest in violence, harassment, or threats, making litigation not only challenging, but in many cases dangerous. So we have, I have listed some ideas of our colleagues of how we can face this kind of challenges, and there are ways to support these communities and strengthen their access to justice. Like I think, let me see who to say it. I think it was Matthew or Roger. International advocacy networks, like by forming partnerships with networks of lawyers, of law firms, NGOs, universities. We can provide consistent and strategic support of these lawsuits, empowering communities to build local capacity or to form long-term support networks. I think is a good way to work. Or strengthening the local organizations is also crucial. NGOs, supporting the NGOs that understand the cultural and legal dynamics of these communities, allow them to act, and trusted intermediaries, bridging the gap of between the community and legal professionals in other jurisdictions. And we have been working here with education and training in legal rights. I think is another good way, like teaching the community's leaders about their rights and available legal representation options. I think this can demystify the processes and empower these leaders to engage more confidently and with the system, the jurisdictional system. And I think this measure can strengthen the capacity of traditional communities in the Global South to overcome barriers, just as justice, and engage the litigation with greater confidence and safety. And for myself, I think we have to support them and ensure that they do not stand alone in this struggle. And I think that is it. Thank you, Elizabeth.
Thank you so much, Pricila, for those extremely valuable reflections. I think it would be great if from the audience, if you have any questions, we're open for questions and answers now. So please pop them into the chat if you have any. And in the meantime, I will continue asking our very esteemed panel further questions. But just feel free to put your questions in the chat, and we will try to address them. So I think of Priscilla's reflections, it would be really great to hear, Jake, from you, I think, in terms of just responses to what Pricila has said. And then I think in addition to this also, on the regulatory side, do you have views on how pro bono could potentially support that, regulatory with respect to Global South, regulatory with respect to Global North, and I think also associated challenges, which probably also may be similar and drawing from what Pricila has mentioned. Thank you.
Thanks, Elizabeth. And yes, all really, really interesting to hear. I think, invaluable reflections there. I think from, from people actually in those communities, or in the case of Pricila, working, with people in those communities. Yeah, I think regulatory action definitely has a role to play. And I'll come back to Pat to respond to Priscilla's particular points when speaking about the role of regulatory action. I think, it has various sort of different guises, doesn't it? I think regulatory action is obviously particularly useful when your focus is accountability, and typically the entities that you're going to be focusing on are going to be business, are going to be commercial entities, because those are who are being regulated. But we shouldn't overlook that government is subject to regulation as well, and there will be regulatory oversight of whole chunks of government. We have a new UK oversight body for government as regards the environment, and that's worth not forgetting about. I think, again, the beauty in some ways of sort of focusing on businesses, particularly large ones, is that they are transnational. They do have real power. They do have the resources to take action, and they are having real impact, both positive and negative. So I think if you can use regulatory steps to sort of alter and mitigate the activity of those corporates, you can have very, very real impact, as I'm sure you know very well. Again, I think, London is becoming quite an interesting place in this space at the moment because of the recent litigation we've seen, for example, around supply chains and around due diligence. And one thinks of the shipbreakers case and so on. Yes, we've seen the Shell case go the other way in the Netherlands just recently, but that may well be subject to appeal. And I think there are some positives there too. I think competition law is probably a slightly underexplored area. That's certainly an area that we're interested in. And we think also consumer law is actually quite a bit more ripe for exploration. But to just touch on both of those two again, in light of what Pricila said, I think safeguarding, if we can call it that, is a very real issue when you're talking ultimately about claims which are going to affect or going to be brought by individuals in the global south. So one of the reasons why we've been exploring consumer law recently is because it can be brought here. So you would, in other words, look at the sort of product that pops out of the end of the global supply chain, about which certain sustainability claims or environmental claims or wider human rights claims are made, and using consumer law here in the hands of British consumers or European consumers or whoever to take action to focus on that. And that kind of mechanism, again, is somewhere where, again, we're going to need a lot of pro bono support, but I think it does help to address some of those safeguarding issues. I agree also, I think Roger mentioned conflicts. I wanted to draw out conflicts at some point. That does make litigation, even in a regulatory context, very difficult, because odds on, if you're in the energy and environment space, the transnational law firm that you really want to work with to take on the transnational business that's, in the eye of the storm is probably conflicted. And that does take you back to this very small group, this very small cohort of sort of claimant-focused actors that Roger has mentioned. I think colleagues have also mentioned that, the amount of scoping and evidence gathering involved in cases makes these cases immensely front-loaded. And that's all got to be done either pro bono, or if it's not going to be done pro bono, we're going to have to turn to philanthropy. And that, again, is going to be, is not indicating that pro bono is not necessarily the only way. I agree. I think the ClientEarth approach is great, and in a small way, that's what we're doing in my team here too. But I think what we find is, even ClientEarth has limits. There are limits on ClientEarth's expertise, and there are limits on ClientEarth's resource. I don't mean that in any way critically, Elizabeth. All I mean to do is to draw out the comparison to an international law firm that has, by comparison, almost limitless capacity, but may well be conflicted. The only other quick thing I wanted to say was, again, I mentioned this particular instance of Bolivia. And what actually happened in that particular instance, we were talking to a major international law firm about this particular set of problems. And two things happened. First, when we said actually we needed to focus on Bolivia, they said, oh, no, we don't actually have an office in Bolivia, which was indicating that even international law firms have limits. But what they did do was they introduced us to partners. So I think there will be, in certain cases, it will be possible for those firms to introduce you to other local partners. And this particular partner was willing to work with us pro bono. But yeah, some reflections there.
Thanks so much, Jake. I really appreciate that. And yes, certainly ClientEarth does have limits, which is why we really love to work with excellent external legal counsel. And of course, I've worked with Will as well. So yeah, I think it's always important across the different spectrum to work together and see where there are gaps and how they can be filled. And I guess that's the whole point of this conversation, really. I guess maybe off what Jake has said, if I could turn to you then, Will, because there's been some discussion about transboundary claims and transnational corporations. So I just want to ask you maybe how you see pro bono legal work evolving in the future to coordinate lawsuits across several jurisdictions. And then I think I saw Matthew have his hand up, and then I'll maybe go to you next. Or was it Roger?
I think it's me.
Okay, sure. So maybe Will, then Roger, and then I will go to Matthew after that. And audience, please, if you'd like to ask questions, please do so. But if not, I'll just keep going with my questions. Thanks.
No, sure. I was really interested to hear Jake's talking about Bolivia and sort of finding sort of pro bono representative counsel in Bolivia, which is not a sort of a surprise specific to Bolivia, but it's a part of an observation that the pro bono market looks very different in different jurisdictions. And I think it's fair to say that England, probably in England, Wales, UK, has sort of one of the most developed and broadest markets for legal pro bono. And I think one of the strengths we have in England, I've always been a strong believer that as a lawyer, you have a sort of core area of expertise, something that you have spent years developing expertise in. And in my view, pro bono works best when you deliver service to client that brings your real expertise to bear. One of the things I'm less comfortable about, and it has its space, but sometimes pro bono almost feels like here we are as sort of sophisticated commercial lawyers, and we're going to go off and do some public law advocacy, which really sort of should be the paid job of somebody who is an expert in that field of law, but there can be an attitude of, we'll go and do that sort of thing on the side. And that always feels a little bit uncomfortable to me. And I think the English market is quite good at sort of saying, no, for pro bono to be serious, we're actually going to sort of use our core expertise and then find projects and find initiatives where we can do that. I think other markets are a bit less like that. And I've spent several years in US law firms. And in the US, there's a very strong commitment to pro bono, but it means different things. And I've certainly had debates in the past where me working for ClientEarth on the sort of projects we handled in Poland and in the Shell case, people seriously saying, well, I don't think that's pro bono work. That's not pro bono within the meaning of the US. So I think different markets will evolve differently. But for the reasons that Pricila and Roger have spoken about already, I suppose the good news, or potentially good news, is that England is a jurisdiction in which one can develop litigation strategies and coordinate action that is not just about things that happen in England. And there have been a series of recent decisions on jurisdiction of the English court, particularly over multinational corporations or companies that have subsidiaries in other countries, which indicate a direction of travel that the English courts will tend to take jurisdiction over claims, even if the claimants in that case are potentially located in Zambia or Brazil or Nigeria. And so the positive is that you can coordinate those international actions, I think, out of England quite effectively. And we in work with ClientEarth down the years have adopted different models, including models thanks to ClientEarth's structure and financing, where I've acted pro bono as coordinating counsel, but we've paid local counsel in certain jurisdictions, and everybody has been happy and it works. And thankfully, the costs of litigating in many other jurisdictions are not as eye-watering as the costs of doing it in London. So that can be a more sustainable approach, I think.
Thanks so much, Will. And I think, maybe just with some reflections of my own, if you don't mind, from Asia, one area of ClientEarth work that we do in Asia is actually pro bono and low bono legal work with counsel on legal analysis, which is then used kind of thought leadership, but I think to mainstream, for example, issues such as directors' duties related and climate related analysis, as well as shareholder climate resolution related analysis. So there can be different models, of course, in different jurisdictions. jurisdictions. I note that Roger had wanted to make an intervention, so I'll pass it to him. But I would also, I think, like to hear after that from Matthew on where Matthew thinks is the greatest need for coordination in terms of pro bono support, coordination between various pro bono initiatives and organizations. So Roger first and then Matthew.
Thanks very much, Elizabeth. A few comments, actually. Some of them related to what you were talking about, about the regulatory field, and then actually some sparked by Will's comments there. So really, coming back to what Will said, I would very much agree that there's actually an issue around how pro bono is seen or defined, and actually, because the little bit of history there is simply because the concept of pro bono was most sort of strongly developed and first developed in the US. We've ended up with a definition which is very narrow and is very much focused upon lawyers going down and representing individuals, in criminal cases or day-to-day access to justice type of cases, and not this. So yeah, we're faced with this every year when we're asked, give us your pro bono hours. Oh no, most of what you're doing isn't pro bono, which is discouraging for a law firm trying to sort of develop the work we do in this area. In terms of the sort of models, though, I think what Will said about a coordination role and putting together, if you like, teams. Which, if you like, have a mixed, and you said as well, this low bono idea as well. I think that sort of mixed idea is really interesting, and I personal experiences, I'm seeing that. And then also, I think what can be quite powerful is the model where the NGO does have deep expertise in a number of individuals, and obviously, Jake is an example of that within WWF. But another NGO I work with called the Lifescape Project, which focuses in particular on biodiversity and rewilding, again has a number of lawyers who are experts and can give that level of expertise, and then draw in pro bono assistance, which might be, if you like, less focused on those areas from big firms, but can provide, if you like, the volume, and work with lawyers also in different jurisdictions. Effectively. So I think some of those mixed models, I think, are quite effective. And then just quickly then coming on to what I end up, it's the regulatory piece. I was just going to say there, I do think that regulatory space is very important. I think it is important to note that certainly with most countries like the UK, the EU, Hong Kong, etc., the focus of regulation tends to be investor protection or consumer protection, and that's what it's designed for. Make sure that the description given by the corporate of its product or its services is accurate, so that investors know what they're doing, and so consumers don't get misled. That's very much what you're dealing with, and therefore driving that in a way which is also positive for climate is sort of using a tool which whose foundational theory is somewhat different, but it can be done. And I would say that the role of lawyers from a pro bono perspective there is, again, going back to what Will said, is those lawyers with deep expertise actually interacting with the regulator through legal bodies like law societies, etc. And I work with the City of London Law Society and its ESG committee. And one of our big roles is to comment upon draft regulation, draft guidance and legislation, and bring it to bear within that context. And actually, again, that's where this line of what we mean by pro bono gets stretched, because that's about lawyers, if you like, engaging with their jurisdiction, with their system, to help design laws and regulation which is effective. And that's often not actually seen as pro bono, but actually it's being done for free. It's not being charged for, and it is exactly part of this ecosystem, very much, I would say. So those would be my comments on that, Elizabeth. Thanks.
Thank you very much for that, Roger. So turning to Matthew then. It'd be great to get your reflections.
Yeah, I think one of the things we did right back at the early stages of the Chancery Lane project, and the advantage of me being a lawyer and the instigator of it, is that I understood that I wanted to use my legal skills, which are corporate and commercial, to make a difference. And I couldn't do that by volunteering to do some litigation in an international context, because I don't have those skills. So it's what skills have you got? And that's where the drafting is really interesting, that non-contentious skill set we have, negotiation, drafting, and thought leadership. And so I say that every lawyer can make a difference. Every lawyer can contribute pro bono, but coordinating that on a global basis is really, really, really hard. Trust me, I know. And so there are some incredible pro bono networks like A4ID, like the in-house pro bono community, and a number of the big firms have collective networks to make sure that they're not all doing the same thing as well. And so there's this unseen coordination that we're not very good at telling the world about, because it's one of the best kept secrets, is that lawyers are actually good people. They just hide it really, really well. And there's all these amazing networks that already coordinate pro bono. And I think there's another one that's just popped up called 1 Million Hours, where they're trying to coordinate biodiversity and climate and environmental pro bono action on a global scale by firms and organizations around the world contributing their projects. And so that's the output of that coordinated action. But I think what all of the pro bono can do, and where it really is brilliant, is it inspires people to do more. And it inspires lawyers with that special agency we've got to do more. And it's, if you show them that it's their legal expertise makes a real impact, then you can connect it to your expertise is our future. And that's incredibly powerful. And one of the things we did to explain that in the Chancery Lane project was the drafting teams named the clause after a child that was important to those drafters. And so what we did by that is we created that intergenerational lens where we put the focus and the emotion allied to the skills of the drafters. And that created this kind of magical nexus where you got the emotion, you got the skills, you've got the legal, and you've got how it helps the world. And I think that's how you coordinate pro bono on both a technical and an emotional level, because I think you need both to make it really powerful.
Okay, thank you so much for that, Matthew. So I think we are almost out of time before I pass to Yasmin to close, but I want to end with questions and reflections from Pricila. So Pricila, I would just really love to get your reflections, and if you have any particular ask regarding pro bono and lawyers' involvement in pro bono work that arising out of this discussion, what would that be, and what reflections would you have?
So thank you, Elizabeth. As I say, the challenges faced by climate litigation, pro bono, and traditional communities are significant and multifaceted. These obstacles range from issues to information to structural limitations that make it difficult to engage, but in the same time, we heard a lot of strategies, or better, something was said about approximate our work to reality. I think we left this debate, this conversation with new ideas and reinforcing the actions we already take. And for me, was really good to be here with you today. I have a question that I didn't ask, but I don't know if we have time, but
I think maybe you can ask if you want. Yeah, maybe just sneak in the question. Yeah, go ahead.
Yeah, if my colleagues, what do you think about what kind of legal strategies could be used on Global South to face climate change? In their opinion, like what is the most urgent strategy that we could use it here? So,
okay, I think we won't have time for everyone to answer that. So I'm just gonna arbitrarily nominate Jake and Roger. Jake first, then.
Sure. I mean, there are two models at the moment, aren't there, Pricila? You know, the one model is where we take the issue, we take the harm that's occurring in the global south and we connect it to a major legal jurisdiction like the UK, like London, and we use the law that is emerging and developing in London to act on behalf of and to create compensation and drive corporate change in the global south, and that's the Mariana Dam type model, I think, isn't it, that Roger was referring to? In my mind, there's then obviously also the opposite. To my mind, the opposite is essentially working with people in community to find mechanisms either in community or possibly even at the international level, which focus attention and focus shine a bright light on what is actually happening on the front line. And we've done that a couple of times recently, including using the UN Special Rapporteur process, which is obviously not a judicial process and doesn't culminate in compensation, but nonetheless was essentially enabling people in community to sort of to bring the these international mechanisms to them.
Thanks so much. So Roger, and I also see Matthew has his hand up, so let's do that.
Yeah, I'll defer. Should I do? Matt, I'll defer to you as you've got your hand up, and then if there's time, I'll go as well.
It's very quickly, one of the things I've been thinking about, and I'd be interested in your views, Pricila, is whether if suppliers from the global south could over-report as a coordinated strategy on the environmental impact happening on the ground, so that it cascades up supply chains rather than supply chains asking for that information in a very specific way. So you create a reverse flywheel of information that actually is then caught in the corporate's knowledge. And I think that could be a really interesting strategy.
That's really interesting. Maybe we should explore this offline, Matthew, but I think we don't have time for any further comments. So I'm just going to pass to Yasmin. Thank you so much to our excellent panel for all their wonderful comments and reflections. It was really a joy to hear this discussion. Over to you, Yasmin.
Thank you very much indeed, Elizabeth. And thank you very much, panel. So as we bring this thought-provoking session to a close, I'd just like to take a moment to reflect on the insights, challenges, and opportunities that have been discussed today. But first, I want to thank everyone for taking the time to join us and for your participation in this event. I hope you found it worthwhile, and I hope that you will also join A4ID again at other such events. I'd like to thank again the organisers of the Climate Law and Governance Initiative for inviting advocates for international development to participate during this day. And I'd like to thank our moderator and the panelists for sharing their expertise and experiences, and also for your thought-provoking contributions. Thank you very much indeed. Not only have you illuminated the complexities, I think, of the legal landscape in the fight against climate change, but also the immense potential that we have to drive change through pro bono efforts. It's clear from today's discussions that the legal profession can, and indeed must, be a powerful tool for climate action. We've heard how, to use Matt's word, the magic of pro bono legal work, and how it can bridge critical gaps, whether it's supporting vulnerable communities that bear the brunt of climate disasters, helping shape and enforce environmental laws, or driving corporate accountability for sustainable practices. Some of the studies that you've heard and the initiatives that have been shared show the profound impact of legal expertise when directed towards climate goals that have advancing on solutions. However, if there's one thing that resonates across all the presentations today, it's that perhaps our work is really just beginning. There's been a lot going on, but it's still in its early stages. The path to climate justice and sustainability requires a long-term commitment, not only from individual lawyers, but also from firms, legal networks, and broader civil society, as we've heard. We've also seen how leveraging our collective knowledge, skills, and resources through pro bono work can actually unlock real systemic change. But to truly accelerate climate action, we need to deepen collaboration across sectors expand our reach and take bold steps towards integrating climate considerations into everything that we do as legal professionals. So one takeaway I hope that I leave with you today is that the work is not reserved simply for environmental specialists alone. Regardless of, as we've heard, of practice area, whether in corporate law, human rights law, regulatory law, competition law, consumer law, or litigation, there are avenues to contribute to climate action. And whether through policy, advocacy, advising on climate-related contracts, or assisting local communities in securing their environmental rights, there is actually a role for everyone. So as we move forward, I encourage all of us to think creatively and ambitiously about how we can continue to apply our legal skills to tackle the climate crisis. Imagine if the impact of every law firm dedicated just a fraction of its resource to supporting climate-focused initiatives. And imagine the progress that we could make if every legal professional took up the mantle of climate justice, even in very small ways. So today's session has reinforced that the legal community has a critical role to play in ensuring that climate action is inclusive, equitable, and just. It's not only about protecting the planet, it's about protecting people, particularly those who are most vulnerable to the devastating impacts of climate change. And actually, that means all of us. So as we leave today, let's take with us not only the knowledge that we've gained, but also a renewed sense of purpose. Let's continue these conversations beyond this session, building momentum and inspiring others in our field to step up and to use their legal expertise for the greater good. We at A4ID are at your disposal. So let's work together and let's go forward with a shared vision and a renewed determination to accelerate climate action through pro bono work. And so on that note, I close this session. Thank you all.